Therapists, sooner or later, your practice is going to intersect with the legal system. If you are a marriage and family therapist, you are going to be part of the crew working on custody evaluations and decisions. And if you are working with individual clients, chances are that eventually one of them is going to be involved in a legal proceeding, particularly with regards to custody, if they're going through a divorce. And so it is vitally important that you understand how this works, and in particular, how the child and family investigation process works so that you can be a strong ally for your clients and help them navigate some of the possible pitfalls of this situation because they exist. And today I'm so thrilled to be joined by my colleague, Stephanie Randall, who is a highly respected family law attorney and also a very experienced child and family investigator. She's based in Colorado Springs. She has years of experience in navigating really complex custody cases. Stephanie, thank you for being here.
Hello.
Hi.
Thank you for having me. It's good to be here again.
And you have another dimension of your practice, and that is as a child and family investigator. And I thought that maybe we could just start there. Can you just explain what is the role of a CFI and what is, in a perfect world, the process for having a child and family investigator come into the mix for parenting recommendations, custody evaluations? Can you just illuminate this for us?
Absolutely.
Yeah.
So in Colorado specifically, there are a variety of different kinds of child investigators. Child and family investigators are supposed to be the least invasive type of child investigator that a court can appoint. And in particular, they're court appointed, non-biased investigators. They're supposed to investigate a specific scope, or specific questions, and then they're supposed to report back to the court in a written report. And then they're of course subject to the ability of being cross-examined at trial, and anything that they relied upon in forming their opinions for their report is also discoverable. So that means that the parties and attorneys can obtain the CFI's files. So the process is confidential to the family and to the court, but not confidential from each other.
And then, so this information is coming back to the court, and then what happens? I mean, how is this
Absolutely.
used?
So typically, a report is supposed to be just a piece of the evidence that the court considers in making decisions if the parties aren't able to come to decisions themselves. So if you look at the best interest factors, which in Colorado, the statute CRS 1410-124, and I would recommend that you read that if you're a therapist that's working with parties in a litigation situation, because that's what the court is looking at to analyze what it's going to order as it relates to the children. And that's the lens that it's supposed to view all of the evidence through. So the report itself is one piece of the evidence that the court is supposed to consider, and the court's not supposed to give any special weight to what an investigator's report says. However, the reality is that since it's the court's expert, and it's, that person's been deemed by the state to have the appropriate training and credentials to stand in that role, the court oftentimes doesn't have better evidence or better information than what that CFI provides. And in situations in particular where parties are unrepresented, or one party is unrepresented, the court may not have evidence because the parties aren't sophisticated enough to present evidence that will actually help the court to make a decision. So that report can become a very critical part of what the court is relying on in making those decisions.
Is a child and family investigator even called into this picture? I mean, because that doesn't happen for every divorce with kids, right? I mean, that doesn't need to be part of a custody decision-making process. But when does a CFI get even requested?
So either party can request, or both parties can request together an investigation, or the court, they call it sua sponte, can ask for an investigator to be appointed. Usually because there's some topic that's very factually bound, especially to evidence that isn't necessarily admissible in court. So child statements, for example, or observation of things, or reviewing information that would be too voluminous or complex or difficult to be presented in the amount of time that the court usually gives parties to present their cases. It could be a CFI, but commonly there could also be a parental responsibilities evaluation. That's called a PRE.
This is so great. And I think that this is what is so important about understanding the CFI process, is really understanding what it is that you guys can do. And just the fact that you can go into people's homes, see what's going on, open the refrigerator, like talk to all the parties involved and really get that sense. Because even, as a therapist, the boundaries around that role are so structured many times. You really are able to gather many data points and get a clear understanding of the context, the environment, all the players involved. But also, could you speak just for a moment about your view of the role of therapists in this investigation process?
Okay, so first I'll speak to it as an advocate, so as a family law attorney.
Yeah.
Therapists are a critical part of my representation of clients. Even if you don't take a major advocacy role or you don't have a role in the litigation itself, you are helping your client deal with the trauma of whatever they've gone through, and maybe the breaking of the relationship, the learning to co-parent, what that means, the sort of radical acceptance of what their new reality is and what they have control over and what they don't.
Yeah.
And even in the best of circumstances, I don't have to tell you or your audience how difficult that is. It's a major breaking, and there's a lot of healing that has to happen. So if you have a patient that's dealing with addiction recovery, and you're helping to support them in that process, which is amazing, and thank you for doing that work if that's something you do, the court is not going to penalize them or punish them for being an addict. What it will punish them for is being active in their addiction while they're parenting.
Yeah.
So if you are helping to support them in remaining sober, then that means that they're going to do much better in the future as a parent and with the court, and have the court's understanding. Especially since, if they're maintaining sobriety and showing their sobriety, and they're working on the underlying symptoms that actually led them into addiction, that's all the court could ever ask of them.
Well, let's talk a little bit more about that therapist-attorney collaboration, because I've gotten these requests, and I also, speaking as a clinical supervisor, I know it creates a lot of anxiety for therapists when these kinds of things come through, where they are being asked to provide information, essentially break confidentiality, but making testifying in a legal system, and so. But tell us a little bit more about what therapists need to be thinking about and doing in terms of working with attorneys, either their own or when these kinds of requests are coming in.
Sure. So obviously, if a CFI reaches out, they're authorized by the court to obtain releases from the parties. So if a CFI is reaching out, they either have releases from the parties already, or they have the ability to get them.
Yeah.
If you don't feel comfortable using the CFI's release that they provide, you're always welcome to provide the release that your attorney or your form that you use in your practice. That's totally fine. But a CFI will, or a PRE, they'll be able to provide the releases that you need to ensure that you're compliant with confidentiality requirements. I would say that if you are a child's therapist, or if you're doing some kind of, family level therapy where you think that there's a child therapist patient privilege, the rules are different and complicated with child therapist patient privilege.
Another thing, though, that I really wanted to speak with you about is a situation. I know that this is a passion area of yours, and it is about the seemingly rising prevalence of what I think of as being really untrustworthy child and family investigators. I mean, there's been more in the media. There have been journalists kind of writing about the situation, concerns from clients, from therapists who maybe have like a front row seat to what's going on here, about unqualified, or I think more commonly, just biased child and family investigators who are making recommendations that don't fully reflect the reality of the family situation. This turns into such a mess. Can you tell us a little bit more about the situation and what you've seen?
Sure. So it's not just CFIs, it's also PREs.
Okay.
But I think across the country, we are seeing maybe the well-intentioned efforts of legislators passing laws intended to add good evidence to family law cases when there's conflict, to give the judge or judges or judicial officers more information in making decisions. And, there have been child advocates around for a long time. In Colorado, they were originally called child special advocates. And then that's what morphed into being CFIs. But like I said earlier, there are also parental responsibility evaluators, and those hold doctorate level credentials. What's sort of been the rising tide of concern is that there have been reports and recommendations disregarding one party's fears and concerns about the safety of the children when placed with the other party, based on histories of violence and threats of homicide and suicide that have resulted in the death of children. And whether it's murder, suicide, or or murder, it's happened far too frequently across the country that children have paid the price for judicial decisions that may have been fed by misguided or poor quality investigations or recommendations. And sometimes there's not good evidence, as you know, because domestic violence oftentimes is not documented.
Right.
Frequently they don't call the police, or if there are recordings of things, they get deleted or destroyed. But I think it's significant and important to remember that the warning signs like strangulation or arrests or threats of homicide and suicide, sort of the cycle of events that happen over and over and over again. Those things that indicate that someone is a lethal risk to themselves and others oftentimes are discredited, or they're just not taken seriously.
Yeah.
And I don't know exactly why that is. I think at times maybe our patient, our person who has suffered domestic violence, they aren't very credible. They're not very believable anymore to the
Right.
court because they're so traumatized that they can't keep their story straight. They can't keep a
Right.
timeline straight. They were compressing themselves and their emotional selves and psychological selves so much just to survive their situation that they oftentimes can't remember everything that happened to them.
So just to recap, so untrustworthy CFIs, and the reason why it is so dangerous is because these people ultimately, like yourself, Stephanie, I mean, you are this firewall, oftentimes really the last thing standing in between a child or family and potentially a very dangerous, even lethal person who could have access to them without that investigation and intercession. So this is a really important situation, and I love what you were starting to talk about what therapists can do and how we can work together to begin improving this system, improving the situation. And so I heard that one of your top recommendations is for you as a therapist to be listening to this, paying attention to what your client is saying. And also, I think the most important thing sometimes is having it in your awareness that even if perhaps this person is a complex trauma survivor, perhaps they have attachment issues where they tend to perceive the worst in other humans, all of those things could be true. And they could also actually, at the same time, being victimized by a child and family investigator or a legal system. And what else? What else can therapists do on that client level to be advocates and allies?
I think one of the most important things you can do is to help your client realize in the shift of their the change in their lives, where they no longer are, the child's only caretaker or primary caretaker all the time. The handing your child over to the other parent, knowing that, maybe they're going to have McDonald's every day, or
Yeah.
maybe they're not going to get the bedtime, or maybe they're not going to have their teeth brushed. And
Yeah.
those kinds of things are so difficult for, for parents, objectively good parents,
Hmm.
to deal with and let go. And that can cause so much stress and anxiety. Helping them understand that while it may not be ideal for the child, um,
Hmm.
ultimately, you don't have control over
Right.
the day-to-day parenting kind of
Yeah, and
decisions
like
at the other
helping them
house.
differentiate a safety issue
Yep.
versus
Yep.
a personal preference because they're
Yes.
different. And to help them calm down
Yes.
with the McDonald's and the toothbrushing could potentially help everybody refocus on
Yep.
actual danger. I do wonder, in just very closing, if we could circle back around to just hearing some of your thoughts about, in particular, the situation related to improving the system when it comes to the child and family investigation process. How could we get involved and kind of throw our weight behind other forces to maybe create even greater systemic change, either legislatively or in terms of the way this process works? Do you have thoughts about that?
Yes, absolutely. But I think in Colorado and probably a lot of places around the country, um, our family law justice system is overtaxed, underfunded, and and well-meaning, but probably failing our families a lot of the time. So the only way that changes happen and how laws change is actually by talking to your state representative. And I personally think in Colorado that we need a family court system that's dedicated to family courts and
Hmm.
families, because the way that Colorado is set up, it doesn't serve families. When a family is competing with jury trials and civil juries that take up 2 weeks or a week at a time in court, and then a family is afforded 3 hours, that affects the future of a family, even
Right.
though it's supposed to be so important.
Stephanie, thank you so much. I feel like I could talk
Thank
to you
you.
for like 6 hours and just be hanging on to your every word. So thank you for spending this time with me today. And
Thank you for
maybe,
having me.
yeah, we'll have the opportunity to visit again in the future.
I would love that.